and cannot justify the first applicant's violation of fundamental rights. In conclusion, we submit that the respondents suspended the first applicant not because it was good discipline, but it was out of fear that the school's 5-year performance record will be affected because of this pregnancy. We further submit that the school's policy is rendered unconstitutional by the need to punish those who are non-compliant with it, which in fact has a negative effect on fundamental rights such as education, privacy, and freedom of association, because the policy necessarily causes violation of fundamental human rights. Therefore, the Denga High School pregnancy policy is unconstitutional. We further submit that it is unconstitutional because it violated her right to freedom, her right to education, even more so because due processes were not followed in the course of her suspension, which her suspension further interfered with her rights to freedom of association with her peers at school, which was another derogation of fundamental human rights. Therefore, Denga High School is unconstitutional. We respectfully request that the court sets aside the decision made at the High Court. We've counseled for the applicant. We further pray for the findings of unconstitutionality of Denga High School pregnancy policy, and further pray for the unconstitutionality of the suspension of the first applicant from school. Therefore, we submit that we further pray to this court that there was an unlawful invasion of privacy in the search of the cell phone. Respectfully submitted.
We submit that our claim to privacy rests on the fact that the cell phone was private property and the information contained therein was private as well.
Sorry, counsel. If one takes a look at section 36, subsection 1, paragraph E of the Constitution, it refers to the limitation of rights, and that particular paragraph E speaks about less restrictive means. Now, from the facts, your client did not want to give out the information of the father as required by the Code of Conduct. So how do you convince this court that there was a less restrictive means to obtain the information other than the LO teacher, just snooping into the phone?
As the court pleases, Section 14, paragraph B, states that everyone has a right to privacy. So the manner that the respondent infringed on the first applicant's personal property was a violation of her privacy rights.
Sure, I do understand the violation, but let's talk. How do you convince this court that there were less restrictive means to get hold of that information?
If the court pleases, may I seek indulgence in that?
That's fine.
As the court pleases, the respondents could have consulted the applicant's parents, as applicants is a minor, and in this case, they should have consulted the parents.
So there were restrictive means?
Yes, there were restrictions.
Thank you.
If the court pleases, justices, privacy and dignity are intertwined with one another. The unlawful search of the cell phone violated not only the first applicant's privacy rights, but also her non-derogable right to dignity by going through her cell phone without her consent. This act alone violated her dignity. Moreover, the actions of the respondents were in violation of Section 9, Paragraph A and B of the Protection of Personal Information Act, which states that personal information may only be processed A, lawfully, B, in a manner that does not infringe on the data subject.
However, the first applicant was suspended on grounds of non-compliance for refusing to give the identity of the father, which is not included in the provisions of the Schools Act, which if a learner is subject to, shall be guilty of serious misconduct. The council then submits the case of Head of Department versus Welcome High School. The court clearly states that the Schools Act limits the power of the school governing body to suspend a learner who was suspected of serious misconduct and for no other reason. Doing so would be in conflict with Section 9 of the Schools Act. If this does not convince the courts, the council then submits that the first applicant at that moment was simply enacting her constitutional rights to privacy at that moment due to the unconstitutionality of the policy that is at question in this matter and the necessity of the policy in its circumstances. Which is why the council puts forth that the suspension of the first applicant was unconstitutional in its purpose, as she was not defying authority, but rather enforcing her constitutional rights. Our last issue is that the suspension of the first applicant infringed on her rights to freedom of education, and the overall conduct of the respondents infringed on the first applicant's rights to association. According to Section 29, subsection 1A of the Constitution, everyone has the right to basic education. However,
I am Tejo Ramnarayan together with my co-counsel Titi Mawire. We are the counsel for the applicant. Our time will be divided as follows. Counsel will be speaking for 9 minutes, co-counsel for 8 minutes with 3 minutes reserved for rebuttal. Council will speak on the following. Section 6.3.4 of the Denga School Policy is constitutional. The search and processing of the cell phone, of the applicant's cell phone, is unconstitutional. My co-counsel will speak on the following. The suspension of the first applicant is unconstitutional. The suspension infringed on the first applicant's right to freedom of education, and that the overall conduct of the respondents violated her right to freedom of association. If it pleases the court, counsel would like to proceed with our first submission. As it pleases the court, we submit that Section 6.3.4 of the Denga School Policy is unconstitutional. This policy states that attention will also be paid to the identity and rights of the biological father involved, whether he is a learner, educator, or a person outside of the basic education system. Section 28, subsection 2 of the Constitution stipulates that a child's best interest is of paramount importance in every matter concerning the child. The information that the school policy asks for has the potential to harm the first applicant and her unborn child's financial future, as the second applicant's job security could be threatened by the prospect of a judicial inquiry. It could also affect the second applicant's prospects of finding employment in the future, as a judicial inquiry could perpetuate bias against the second applicant because of the unfounded accusation of abusing a minor, noting that explicit consent was given by both the first applicant and the second applicant, and that this was communicated to the respondent.
Counsel, if I may just ask.
And privacy. In this case, the group unit, the family unit in the situation would be the first and second applicant, as well as their unborn child. The Denga School pregnancy policy was applied destructively, placing both the applicant and her unborn child in danger by placing them under significant emotional and physical stress in the early stages of pregnancy. Counsel for the applicant therefore further submits that the applicant's right to a basic education and freedom of association was denied and violated, as she was eventually unjustly suspended after the identity of the father of her child was exposed. Counsel for the applicant therefore argues that in line with Section 29, subsection A of the Constitution, as well as in the case of Anthony versus Governing Body, Settles High School and others, the respondent has infringed upon the applicant's right to a freedom of association, as well as the access to a basic education. Following the identity of the first applicant's partner and personal information being exposed, a consultation was held, and with the approval of the school governing body, the respondent then proceeded to unjustly suspend the first applicant from school for a period of 5 days on the grounds of her defiance of authority and failure to cooperate with the Denga teenage pregnancy policy procedures. However,
In applying this corrective measure, the respondent has failed to uphold Section 9, subsection 1 of the Schools Act of 1996, as the first applicant was suspended without having a fair hearing, as it was set for the 5th day of her suspension, which clearly indicates the severity of this correctional measure in relation to the alleged offence, that is, her non-compliance. This action has infringed upon the first applicant's right to freedom of association and basic education, as due to this unjust suspension, she was unable to interact with her peers nor attend school for 5 days. The applicant is a student, and interacting with her peers is an integral part of the teaching and learning process and experience. Therefore, by unfairly suspending the first applicant, it does not only violate Section 29A of the Constitution, but also infringes on Section 18 of the Constitution, as she was denied association and interaction with her classmates.
With the school's policy, and for this reason, justifiable methods had to be taken, since it proved to show that Ms. Mudau exempted herself from the obligation to comply with the school code of conduct. She is obliged from the day of enrollment to comply with the school's policy. Yeah, because the parent who the child is under the wing of consented that my child will comply with the school policy no matter on what grounds. And in the case of head of Department of Education, 5th Province versus Welcome High School, paragraph 229, it is stated that in the terms of Section 9, subsection 1 of the Schools Act, the governing body's power to suspend a learner from school is limited to those cases where a learner is suspected of a serious misconduct. And as per the case of Anthony, paragraph 19, it is also stated that the nature of the misconduct must necessarily assist in determining what constitutes disgraceful, improper, or unbecoming behavior. Defiance of authority and failure to comply with the school's policies, section 6.3.4 particularly, can be classified as a serious misconduct, since it proves to be disgraceful for what the school has done for you. Improper, showing you are being unruly right now, and it is also unbecoming. Ms. Mudau proved to be unruly and posed as a threat to the school's policy, meaning that, taking into consideration that the school is able to set out a policy, but learners of the particular school do not comply with it. So for that reason, justifiable measures had to be taken.
In the instance, both I and my co-counsel will suggest to take a maximum of 10 minutes each for our presentation, if it pleases this court. First among the rest, as legal attorneys for the respondent, we submit that the applicant's right to privacy has not been infringed by the respondent. And yet we also make a submission that the Denga Teenage Pregnancy Policy, relevantly section 6.3.4, is not unconstitutional for only this possible reason. This typical policy is truly identical to the Department of Basic Education policy. Secondly, it serves a purpose in establishment, which is truly procuring teenage pregnancy at Denga High and addressing the issue of teenage pregnancy. In accordance to the South African Schools Act, Counsel for the respondent would suggest to rely on Section 8 of the South African Schools Act, Code of Conduct, subsection 1, that states that any code of conduct that is adopted by an organization or forum should be in the real consultation with the learners, the parents, and also the educators. It also has been stated that the Denga High School has a well-functioning school governing body. Now this shows and demonstrates that the adoption of the Denga policy was truly in the essence of public interest. Moving on, counsel for the respondent therefore submit that alleged applicant 1 right to privacy was limited in terms of section 36 of the Constitution. The limitation of section 14 is justifiable according to section 7 of the Constitution, right, subsection 3, that states that the rights in the Bill of Rights are subject to the limitation and contained or referred in section 36 or elsewhere in the bill. Section 36, on the other hand, states that in subsection 1, the rights in the Bill of Rights may be limited only in terms of law of general application to the extent that the limitation is reasonable and justifiable in an open democratic society based on human dignity, equality, and freedom. In application of section 36, counsel for the respondent was supposed to submit that the limitation of alleged applicant 1 right to privacy was to truly analyze closure and to truly restore the word responsibility. In accordance to section 39 of the Constitution, interpretation, in accordance to case law based on paragraph 67 that states that no right is considered absolute, implies that from the outset interpretation, each right is already limited by every other right accruing to another citizen. As legal attorneys for the respondent, we argue the basic justice factor in the aligning context of case law based on that the right to privacy may be limited, and in this case, it has been rightfully so. However, in consideration of an international law, Section 39 of the Constitution does require the court, a tribunal, or forum to consider international law when interpreting the Bill of Rights.